Okay, so here is the detailed analysis I was promising. For you, those of you who have been impatient, waiting for this to happen, I can only say we've been waiting on the written decision. As you can see from this screenshot, which I took around 10:30 a.m. on August 15th, the decision itself hasn't been uploaded to the publicly accessible database where they're supposed to upload these decisions. So, literally 15 days after the decision was read in court, still was not transcribed and up. And so Allison finally ordered a transcript to be produced at HBB's expense. So that's why I have this now, and I'll be keeping an eye on the CanLII website to see exactly when they do upload the decision for public consumption. Now, why did I wait for the transcript? Basically because going by memory and notes regarding something complicated like an oral decision with reasons, that's just not the best way to go. No one in Canada, other than the court itself, is allowed to video or audio record anything that goes on inside a courtroom. And they create transcripts based on their recording. They don't make the recordings themselves available to anybody in general, and so there you go. And I balked at going from memory. I don't want to get things wrong. And there have been a few things that I and Allison have commented on publicly. But those were things that, I was really, really certain of. Things that just stuck out in particular. And there was just no way that I could, commit such a lengthy oral decision just to memory. I'm not a savant, so there you go. Anyway, at long last, we have at our expense the decision in our hot little hands, and I'm going to go point by point, reading the judge's reasons individually, then commenting on them immediately after. Now, there are some things I'm going to leave out because they're just sort of general descriptions. The first bit is just a general description of the basic details of the case, who is suing whom and why. There's really no need to bore you with that stuff. So let's just get right into the reasons. So the judge notes, in brief, the defendant Calgary Comic alleges the plaintiff breached the defendant's policies and were removed as an exhibitor. The contract is comprised of an application form being submitted with appropriate fee and acknowledgement that, among other things, the plaintiff would adhere to Calgary Comic's policies. So there was a little box saying, I agree to all the terms and conditions, and the terms and conditions were in all of the policy documents attached to that. So the plaintiff's expenses in preparing for, traveling to, and setting up at the expo may be recoverable damages in whole or in part in the breach of contract action if a breach is established. The removal of the plaintiff's booth partway through the exposition was at the defendant's discretion, subject to contractual obligations. The plaintiff had full knowledge of what she was signing and what she was signing up for. The defendant, Calgary Comic, is a private commercial operation, and prospective clients are free to apply or not as they wish. The plaintiff asserts the notion of unequal bargaining power ought to be a consideration. The unequal bargaining power submission is not applicable in these circumstances. She applied to be an exhibitor with eyes wide open, fully knowledgeable with respect to the terms and conditions under which the defendant operated and to which she was subject. Okay. First thing, the documents attached to the contract stipulated that all complaints would be investigated, and it describes the investigative process, which includes getting both sides of the story. It also described a step-by-step process of remedy that would be used, to remedy even sustained complaints. Namely, the first step would be to ask the offending party to cease the offending conduct or remove the offending materials. Further, the policy documents describe unwarranted accusations as a form of harassment. Now, what this means is that Allison had an obligation to abide by the terms and conditions spelled out not only in the application form, which was just a simple transaction of money for an application, an approved application, but in the policy documents attached to the application. So, basically what Allison was signing up for was spelled out in those documents, right? And that includes right? The policies and processes Calgary Expo had outlined regarding their own responsibilities, right? Regarding their complaint and investigation procedures, as well as their procedures for remedy. He says, she went in with eyes wide open, fully knowledgeable with respect to the terms and conditions under which the defendant operated. Well, yes, those were spelled out in the policy documents, the terms and conditions under which the defendant operated. So that's what she was signing up for. Now, the only clause in the contract that would relieve Calgary Expo from its own duty to abide by the terms it itself had laid out reads as, the CCEE shall have the full power in the interpretation and enforcement of all contract regulations contained herein, and the power to make such amendments thereto, and such further rules and regulations as shall be considered necessary and proper, end quote. Now, not only is this clause arguably a violation of the Alberta Consumer Protection Act, and something that really should never stand up in court and usually doesn't, in that it grants Calgary Expo the authority to ignore its own contractual obligations as stated by it in its own documents, it does indeed raise the issue of unequal bargaining power. That clause alone raises the issue of unequal bargaining power. If Party 1 to a contract is signing a contract filled with terms and conditions written entirely by Party 2, while a single clause in that contract indicates that Party 2 is effectively signing a blank piece of paper upon which it can choose to write anything it wishes for any reason or no reason at all, then the contract isn't actually a contract. Now, a lot of contracts used as boilerplate by corporations like the Expo include clauses just like this, despite their dubious ability to succeed in court, because rubes and noobs who read that clause will believe they have no legal recourse. They can't sue because, hey, these guys said in the contract they could do anything that they wanted. So those people won't file a lawsuit or a complaint with consumer protection agencies. But what the judge seems to have done in this decision is uphold a clause that is in direct violation of consumer interests and consumer protection laws in Alberta, because that's the only way I can see him claiming that Allison had an obligation to live up to the terms and conditions in the policy documents, and the Expo also did not have that obligation. Moving on. There was no misrepresentation by the defendant of any sort and no evidence of bad faith. In fact, evidence shows the plaintiff's application and the plaintiff were dealt with fairly and in a courteous manner, at least up to the point of expulsion. Yeah, things were going great until they weren't. Calgary Expo treated Allison fairly right up until they decided not to. My tenant paid the rent on time every month until she stopped. My spouse was faithful to me right up until he cheated. I paid my credit card balance until that period of 6 months when I didn't. This assertion is irrelevant and nonsensical. It has zero bearing on whether a contract was violated. That guy had no cause to complain about my behavior, at least until the point where I punched him in the face for no reason. Like, that doesn't fucking make any sense. Good grief. Next. The defendant, Calgary Comic, received complaints about the plaintiff's participation at a panel discussion and also about a banner at her booth. The defendant investigated. The investigation was not thorough in that the plaintiff had little, if any, opportunity to provide her version of events. Now, first thing. Allison didn't have little, if any, opportunity to give her version of events. She had no opportunity to do so. She even informed Calgary Expo's Chief of Operations, Shane Henkelman, that she had an exculpatory recording of the panel discussion and he refused to even consider listening to it. Now, I suppose little, if any, might be applicable to, but I'm innocent and can prove it. But at the same time, Henkelman testified that the decision was made before he even spoke to Allison that morning. So, yes, there was no opportunity for her to give her version because the decision was made before he even came into contact with her. Secondly, how is this not thorough investigation sufficient to come to a decision to evict? If the contract Allison signed indicated that all complaints would be investigated by getting both sides of the story and would be remedied in a gradual manner, as outlined earlier above. The first thing that they would do is ask you stop the offending conduct. Next. The defendant said it received complaints from guests, news organizations, and from the Mary Sue. It went online to learn more about the prominent Gamergate banner at the plaintiff's booth. Now, this is weird because, to my knowledge, Expo received no complaints from the Mary Sue, or even any employees or agents of the Mary Sue, nor did Shane Henkelman testify that they had. Also testified to by Mr. Henkelman was that complaints were received from media personalities, not from official news media accounts, but from people in the media who have a bit of a reach. So it's kind of like the difference between saying Tucker Carlson tweeted X and Fox News tweeted X. In this case, Tucker Carlson may have tweeted something, but Fox News stayed out of it. Now, this is a really strange mistake for the judge to make, since had the Mary Sue officially complained about us to Calgary Expo, this would have actually helped implicate the Mary Sue in any inducing breach of contract claim, particularly if the complaint had no merit. Next, the online information about Gamergate was unsavory to say the least, and in the view of the FBI, Gamergate is a vehicle used to disseminate hate messages, among others. Unsavory coverage, like the coverage of Allison and Honey Badger Brigade following our expulsion. Unsavory like that. Anyway, the judge's assertion about the FBI is actually directly contradicted by the only evidence regarding the FBI that was presented at trial. This position attributed to the FBI couldn't even have been found by an improper out-of-court research session. The FBI investigated Gamergate over accusations that it was a hate movement. It found no actionable leads. Law enforcement, I think they identified 4 individuals who'd sent potentially actionable messages, one of them a minor, and chose not to prosecute any of them. One of these messages was clearly a joke, at least to anyone who's ever spent any time online. They claimed to have over 9,000 bombs. These were very, very iffy. No prosecutor chose to prosecute these individuals. One of them was a minor. One of them was clearly a joke. So essentially, what you have is a report by the FBI that said this is just a great big nothing burger, right? Okay, moving on. With respect to the breach of policy application, in order to succeed, the plaintiff must show on a balance that the defendant Calgary Comics' reliance on its policies was sufficiently unfounded to constitute a breach of its contractual obligations. Regardless of the quality of the investigation and regardless of the fact that the defendant's reasons for its decision may well have been debatable, it had the contractual right to remove the plaintiff's booth, subject, of course, to its contractual obligations to the plaintiff. Again, aren't those obligations spelled out in the exhibitor agreement and other policy documents attached to the contract? Again, we are back to this idea that vendors have an obligation to abide by the terms and conditions laid out by the Expo, while the Expo has no such obligation to abide by the terms and conditions it laid out. Again, we're back to that sticky, we reserve the right to do whatever we want for any reason or no reason whatsoever clause that, if legal, would certainly make unequal bargaining power a consideration. Next, the plaintiff denied being disruptive at the panel discussion and provided a transcript and audio recording to support her assertion. Both the tape and transcript are somewhat supportive of the plaintiff's position. However, the quality of the recording makes it difficult to discern what is said and by whom. I recognize the difficulty in marshalling this kind of evidence. However, I don't know if the portions provided are the complete exchange in issue, much less whether they are the portions complained of. A couple things. First off, the judge spent much of the trial reminding counsel and witnesses to speak up because he's hard of hearing. I would suggest that it being difficult to discern what is said and by whom might be owing to a disability on the part of the judge rather than on the quality of the recording itself. In addition, the judge had ruled against listening to the entire recording at trial. When asked why she wanted to play the entire thing, Allison responded that she wanted her participation to be viewed in the full context of the entire discussion. Defense didn't want to listen to the whole thing. Neither did the judge. Frankly, neither did I. And both defense and the judge indicated that they would take her word for it, that the excerpts were satisfactory in that regard. For the judge to now complain about the incompleteness of evidence he himself ruled against hearing in full, well, that's just fucked up. Moving on. While debatable, I cannot conclude on balance that there is sufficient credible evidence to conclude Calgary Comics' assessment of the information it received and gathered, and its application of that information to its policies, was a sufficiently inadequate misinterpretation or misapplication so as to constitute an improper application of its policies, and thus a breach of its contractual obligations to the plaintiff. Holy run-on sentence. Thus, there is insufficient evidence to support the breach of contract claim against Calgary Comic, and accordingly that claim is dismissed. Okay, so again, these are policies which state clearly that an investigation involves getting both sides of the story, that unwarranted accusations are themselves a form of harassment, and which also state that remedy begins with asking the offending party to cease the offending conduct, that is, putting people on notice. Now, the Expo acted precipitously and summarily on information it received and gathered from everyone but the plaintiff, and it bypassed all of the steps it outlined for both investigation and remedy to level the most extreme punishment available to it. Not just expulsion, but a blanket ban on attendance of future conventions. Further, Henkelman testified on the stand that even had he known that all of the allegations in the various complaints against Allison that were made to the Calgary Expo were false, he would have ejected her anyway. He came right out and admitted that after being asked more than once. So what we are left with is Allison's alleged association with a hashtag called Gamergate standing as the sole reason for her being evicted. But at the same time, there was nothing in the contract or the surrounding policies or exhibitor agreement at that time putting anyone on notice that presenting a Gamergate logo on a banner promoting anti-censorship and pro-ethics values would be in violation of any of the Expo's policies. There was nothing in the contract or policies prohibiting expression of affiliation with any movement, hashtag, political opinion, cause, or philosophy. So, essentially, she got kicked out because of Gamergate, and there was nothing in the contract that even mentioned Gamergate or anything similar or applicable to Gamergate. Okay, so now we move on to inducing breach of contract. The judge says, with respect to the inducing breach of contract claim regarding the Mary Sue, the defendant, Calgary Comics representative, testified he had no contact with the Mary Sue apart from receiving the complaint about the events in question prior to the decision to expel the plaintiff from the exposition. There is suspicion by the plaintiff that the Mary Sue and Calgary Comic may have collaborated or colluded, and that the Mary Sue may have slagged the plaintiff, thereby inducing Calgary Comic to act as it did. But there is insufficient credible evidence, supporting evidence in that regard, and thus the inducing breach of contract claim against the Mary Sue is dismissed. Now, this is just really not accurate. Again, Calgary Expo received no complaints from the Mary Sue or from any agent of the Mary Sue. He may be referring to the complaint from Brittany LeBlanc, one of the panelists, but neither Allison nor Shane ever said there were complaints from the Mary Sue. As for the suspicion of collusion, yes, that was our suggestion in our initial finding back in 2015. However, over time, as more evidence came to light, and particularly through the evidence exchange, but also through digging online, the scenario we presented at trial and during our final submissions, that was very different. The scenario we presented was that Sam Maggs had sent a photo of our booth to her friend and collaborator in Toronto, Soha Karim, who tweeted it out. and that this single tweet, and it was what led to all of the complaints on social media from guests and news media personalities. Those complaints that Hankelman cited as, I guess, the ultimate reason he kicked us out. That is, the complaints led him to take other actions, which led to that decision. So without the complaints, he none of this would have happened. In addition, our contention was also that Sam Maggs spoke privately to Brittany LeBlanc, and in our belief, convinced her to complain to Calgary Expo about Allison's participation at the panel discussion. And this was another reason Hankelman cited in his testimony as contributing to his decision to kick us out. Basically, he presented these as reasons to look into us. And when he went online and looked into us and into Gamergate, he lost his freaking marbles. So our contention at trial was that Sam Maggs, editor for the Mary Sue, intentionally set out to generate a social media controversy with us as the target in order to create news for her website to then report on. And wouldn't you know it, the Mary Sue scooped the story. They beat everybody to the punch. Now, we certainly had more evidence supporting that conjecture, that Sam Maggs, in her position as editor of the Mary Sue, orchestrated a social media controversy through a known associate, a social media controversy that was the ultimate cause of our expulsion, according to Hankelman. Yet the judge did not touch on this at all. Not even to say it was far-fetched or a conspiracy theory or even that our evidence was insufficient. He just ignored it. He just ignored it. Anyway, moving on. The judge notes, there is insufficient credible evidence that the defendant, Calgary Comic, published anything, much less any false statements disparaging the plaintiff's goods or property or business. Having her booth removed from the exposition for breach of the defendant's policies without more does not constitute a false statement. True enough. Publication of the fact of removal of the booth for breach of policy without more is also not a false statement. Okay, I'll grant that it's not necessarily a false statement. That is, if the breach of policy in question had occurred, or if a fair investigation adhering to Calgary Expo's contractual obligations had occurred, even if the finding was wrong. Right? A false statement doesn't require someone to know the statement is false. Malice in the context of false statements can include not taking the proper care to check. Now, the Expo had contractual obligations to take proper care to check, as it itself laid out in its policy documents and attached to the contract. It did not do so prior to its decision that we had violated policy, nor before its publication of that decision that we had violated policy. So, Hankelman's testimony described a rush to judgment and summary execution completely devoid of taking any proper care to check as to whether he was working with actual facts. And in fact, in his final submissions, he described this as the first and only case in which he himself ever kicked anyone out of one of the events he ran on behalf of Calgary Expo. So that's pretty much all of them in Western Canada for a number of years. And he has never kicked anyone out before us and never kicked anyone out since. Now, are we to believe that no one else has ever been kicked out from a fan expo in all of Western Canada for the last 4 years? No, we're not. Maybe what we should be believing is Mr. Hankelman's testimony that he, as chief of operations, took it upon himself to unilaterally bypass all of the expo's dedicated personnel and procedures, and all of its obligations as spelled out in the policy documents, and made what amounted to an executive order in violation of the Expo's contractual obligations. I think that that's really the gist of everything that he said, and that is exactly what he did. He said, well, I can't leave this to the normal personnel who investigate these things. I can't leave it to security. I can't leave it to someone, below me in the totem pole, the people who are actually paid to do this work, right? No, I'm going to take it upon myself to circumvent and bypass all of the safeguards and all of the procedures involved that they laid out in their policies to ensure that they would not wrongly eject someone. And and he just went straight to the harshest punishment he had available to him. Okay, publication by others of the expulsion and the purported reasons for the expulsion are not actionable against the defendant Calgary Comic. The defendant Calgary Comic did not publish the fact of the expulsion or the reasons for it. Tweets by others posted on the Calgary Comic website about the expulsion were quickly removed by it. Alternatively, if the tweets by others could be characterized as publication by Calgary Comic, there is insufficient credible evidence that the tweets contained false statements about the plaintiff's property, goods, or business. Okay. No. First off, the tweets were not published on Calgary Expo's website. They were published on Twitter. Calgary Expo cannot remove tweets made by others from Twitter. It can only remove its own tweets. Further, it cannot make tweets made by others invisible to anyone but itself. And secondly, in direct response to a tweeted query as to why we were kicked out, Calgary Expo's official Twitter account tweeted the Mary Sue's article. A tweet constitutes publication of everything contained therein, including links. And finally, Hankelman testified on the stand that he ordered the tweet deleted when he learned of its existence. His stated reason, under oath, for doing so was that the tweet was actionable. In other words, Calgary Expo published actionable statements it knew might be false, and Hankelman ordered them deleted because they were actionable. His actions in deleting the tweet and his stated reasons for doing so were an admission that the tweet itself was indeed actionable under the law. This tweet was not made by others, but by Calgary Expo's official social media account, manned by employees and agents of Calgary Expo and working under Calgary Expo's authorization. So basically, out of everything that was testified to in this entire trial, right, everything Shane Hankelman said, this is like the one place where the judge didn't give him the benefit of the doubt. When he said, yeah, the tweet was legally actionable. Next, if I am wrong that the defendant did not publish statements about the plaintiff's goods, property, or business, there is insufficient credible evidence that any such purported statements were false. Now, this is bizarre since the tweet contained a link to the Mary Sue article in direct answer to a query as to why we were kicked out. So, why were you kicked out? Here's why, everything in this article. Now, the article describes Honey Badger Brigade as a business run by someone who lies on her business contracts in order to clandestinely gain opportunities to enter events and cause disruption and harass people. Now, Allison did not lie on her contract. There was evidence of that presented at trial. We did not sneak into the convention either. And while we were there, we harassed no one. And there is credible evidence. It's there in the booth application that was submitted to the court, in our badges and booth decal that identified exactly who we were. And the judge himself is the person who ruled that we would not hear the entirety of the panel discussion that would have provided credible evidence, absolute confirmation that Allison had harassed nobody at that panel discussion. He goes on, in the further alternative, if I am wrong about the publication and falsity of content, there is no credible evidence that the defendant, Calgary Comic, was motivated by malice. The evidence showed that the defendant received complaints about the plaintiff's conduct and about a banner at her booth, and after some investigation chose to have her booth closed and removed from the exposition. Now, he really seems to be wanting to cover all of his bases, in the further alternative. If I'm wrong about this, if I'm wrong about that, then this other thing. However, malice, a conscious, intentional wrongdoing of a civil wrong like libel, with the intention of doing harm to the victim. This intention includes ill will, hatred, or total disregard for the other's well-being. Calgary Expo's policies attached to their contract clearly state that unwarranted accusations are considered a form of harassment and that its investigation of complaints will take into account both sides of the story. Calgary Expo's contravention of its own stated policies and procedures in this case certainly displayed no regard for the well-being of Alison Tiemann when it summarily ejected her despite her telling them she had exonerating evidence. When Calgary Expo promoted the Mary Sue article in response to questions as to the reason it had evicted Alison, it also did so with total disregard for her well-being. Calgary Expo's social media team did not take time to verify whether any of the allegations in the article were true or false, and it could have easily done so, at the very least in regard to the misrepresentation claim in the article prior to making the tweet. So they actually had the evidence that Alison did not misrepresent herself in her booth application. They had the booth application, right? And yet they didn't even check that before they tweeted the article in response to the question, why did you kick them out? And further, when Calgary Expo deleted the tweet, by Shane Henkelman's own admission, they did not do so to ameliorate any unjust damage that may have been done to Alison, but merely to protect themselves from what they knew were legally actionable statements on the part of Calgary Expo. Now, to this day, Calgary Expo has not so much as corrected the public allegation that Alison lied on her contract with them, despite having submitted evidence to that effect to the court, which also certainly displays a continued disregard for her well-being. He continues, "There is no evidence of animus towards the plaintiff or bad faith in investigating the complaints, notwithstanding Calgary Comic did not obtain the plaintiff's input prior to its decision to expel." Again, except that it did not follow the investigatory protocols laid out in its own policies and agreements. It refused to listen to evidence Alison claimed was exculpatory. That's the definition of bad faith. That Mr. Henkelman and the Expo were nice to us right up until the moment that they weren't is immaterial. Expo did not follow its prescribed step-by-step procedure for remedy even when someone has been found to be engaging in offending conduct. It skipped over all its normal procedures, jumped directly from accusation to summary execution. As to animus, Alison was informed that if the booth was not dismantled and all of us out within the space of half an hour, Mr. Henkelman would call police and have us all arrested. He refused to provide us with tools when asked so that we could disassemble the booth without damaging it. He testified that following our eviction, he sent spies to infiltrate our social gatherings and report back to him. He put Stampede Security on notice that we were a clear and present danger to attendees of the convention, such that Stampede Security called police on our peaceful and completely innocent picnic at Reader Rock Garden the Sunday after we were evicted. No evidence of animus? He goes on. Lastly, if I am wrong about publication, falsity, and malice, the plaintiff has not led sufficient credible evidence to establish special damages. Damages are not presumed, and general damages are not recoverable. The plaintiff incurred expenses to attend the exposition, but these expenses were not a result of this alleged actionable tort. Okay, now what he's saying here, when it comes to special damages are actual losses. So whatever follows from the actionable tort, the actionable wrongdoing, if there are actual financial losses. So if somebody, if I was trying to sell a home and I'd negotiated a purchase price and then somebody came in and said that there was a bunch of, radon gas or something in the house and lied about that to kill the sale, right? I would have the sale price of the house. That would be special damages because the sale's done, it's gone, I can't sell the house now. He's completely freaking slandered my property, my house, as being deadly, full of deadly radon gas. And So I'm incapable of selling it, at least for the price that I originally wanted to sell it for. So I can claim special damages. General damages are for things like pain and suffering, inconvenience, damage to reputation, things like that. And those aren't actually a thing in an injurious falsehood claim. Um, so the damage to the booth and those kinds of things, they would be recoverable if Calgary Expo was found to have breached their contract with us. We would be able to recover those. But those are not recoverable from what followed after we were evicted. So she has to prove that there is a pecuniary loss attached to the Mary Sue's article and the Calgary Expo's promotion of the Mary Sue's article. Right? And all of that would have had to have occurred after the publication of that article. So basically, he's right in this, right? In terms of, damages are not presumed, general damages are not recoverable, and the damage to the booth is not recoverable via the injurious falsehood tort. But I think he's making a big leap that being smeared in both mainstream and industry media couldn't be reasonably expected to hurt Allison's bottom line in her chosen industry. So all of those comic websites, review websites and stuff like that won't review her comic, all of the comic book stores that don't want to carry her comic book, all of those things, right? Those are reasonable expectations given what occurred in the media after the Mary Sue's article and after Calgary Expo's Twitter confirmation of its contents as being the reason they kicked us out. Damages are not presumed, but a reasonable expectation of damages does not mean the plaintiff must present an itemized list down to the penny of every single loss suffered. It doesn't require a plaintiff to be clairvoyant and prove beyond a reasonable doubt that if not for the defendant's actions, they would have sold exactly 2,113 more units of merchandise than they otherwise would have. That is not required in order to actually prove pecuniary damages. You just have to essentially demonstrate that you would have been able to market your product in places where you're no longer able to. You would have been able to sell your product in places you're no longer able to, and all of those things. And the losses themselves, the actual dollar and cents amount of them, that only comes in when you're deciding what's owing in damages. So there you go. Moving on, the plaintiff's husband testified that she had sold about 30 comics in her entire career. Now, this is a really weird thing, because plaintiff's husband also testified that he had no real idea how many comics she'd sold, and he really didn't want to answer the question because he said he had no clue, and that, okay, if I absolutely had to guess, right? And so this is the number the judge seized on. A subsequent witness who was manning the booth testified that 7 copies of Allison's comic were sold in the first 4 hours of the convention alone, the least trafficked day, or half day, the first half day. So projecting from that, Allison could have expected to sell a total of 50 to 60 or more comics over the full 4 days of the expo, had she been allowed to stay, right? Which would have essentially doubled the guesstimate, I have no other way to put it, of her husband, who really has not been paying attention to how many comics she sells. And regardless, just because she had only sold X many comics, therefore there were no damages, therefore she was deprived of future sales. If one convention alone was capable of doubling those sales, her lifetime sales, right, then I think that that's evidence of pecuniary damages. And there's no lower bound on, what constitutes pecuniary damages. There's no, oh, you had to have lost a minimum of X amount of dollars. No, you just have to have lost money. Carrying on. The plaintiff testified she experienced difficulty convincing store owners to carry her product after this event. There was insufficient evidence of the magnitude of her difficulties, much less a dollar amount to specify the amount of alleged special damages loss. Thus, the injurious falsehood claim is dismissed against Calgary Expo. Now, this is actually a mischaracterization of what the testimony was. Allison actually testified that a store owner in Saskatoon had not only stocked her books, but it had placed them on prominent display because they wanted to promote a local artist. And after the incident and the media fallout, that shop owner took down the display, kind of tucked her books off in a hidden corner of the shop, and cut her orders by about 75%. So that is an actual quantifiable loss right there. But again, there's no specific down to the penny requirement under injurious falsehood as to what determining as to determining that there were special damages, nor a minimum amount necessary. The fact that there were special damages can be reasonably assumed given all of the circumstances. And if there is a reasonable expectation that Allison had lost out on the sale of just one book due to this fiasco, that would be enough to constitute special damages. Now, the amount of special damages, again, only becomes relevant when deciding what, if anything, is owing to the plaintiff, right? And this lawsuit has never really been about recovering money. It's always been about the principle, the underlying principle of the thing, right? That Honey Badger Brigade and Allison Tiemann were wronged by Calgary Expo when it breached its contract with her, that the Mary Sue wronged her when they published that article, that the Mary Sue was involved in inducing the breach of contract, setting up the circumstances in which that happened, and that the Calgary Expo in its promotion of the Mary Sue's article also wronged Allison and Honey Badger Brigade by spreading false information about us, false and defamatory information about us. That impacted her ability to do business as an independent comic creator, which it clearly did. Anyhow, moving right along to the injurious falsehood claim against the Mary Sue. Judge says the Mary Sue did not participate in the whole trial. It did not lead evidence, nor cross-examine, nor make submissions. It published an article after the expulsion. Some of the content may be false, and it may have been written maliciously. Assuming without deciding that there was publication, maliciousness, and falsehood, I would dismiss the claim on the basis that there was no credible evidence that the plaintiff suffered special damages attributable to the Mary Sue publication. Thus, the injurious falsehood claim is dismissed against the Mary Sue. So, again, there's no requirement for specificity regarding an exact dollar amount to prove special damages, nor a lower bound as to what is considered a pecuniary loss. A reasonable expectation of loss is sufficient to prove injurious falsehood. Anyway, there is so much that's haywire with this decision, it's not even funny, and I think I counted like a minimum of 16 grounds on which we can appeal. That's not even considering some of the errors of fact-finding that occurred, which I think should actually be viable cause for appeal as well, because it indicates that the judge did not have a proper grasp of the facts. I find the most interesting thing, perhaps, about this whole thing being that the judge disregarded Henkelman's own testimony that the Calgary Expo's tweet was actionable. I think that that's absolutely bizarre. And his finding of no animus is completely belied by the manner in which we were kicked out. Henkelman refusing to hear exculpatory evidence, even threatening to have us arrested if we weren't gone by the time the doors opened to the public. He advised Stampede Security we were a threat to the safety at the convention, and he sent staff members to spy on our meetups. There's really no evidence of animus there. He seems to have been conflating or confusing when the animus came into being with it not having been in existence. Basically, the moment that he, I guess, went Googling, that was when the animus came into existence. The fact that he didn't have any animus against us before that is really immaterial. And I would like to just add one last thing. Perhaps the most ironic thing of all about this entire case um, was that all of that animus appears to have been based on the egregiously biased, misleading, and demonizing media coverage of Gamergate that falsely painted a hashtag and a consumer revolt as nothing more than something sinister, misogynistic, and dangerous. And the result of the actions that Henkelman took based on that biased, misleading, and demonizing information was the result of that was egregiously biased, misleading, and demonizing media coverage of Honey Badger Brigade and the events of 2015. So I guess their media narrative remains intact. And we are all bad people now. So, anyhow, that's it for me. And I'm gonna go pet my dog.